Hello, everyone. Thanks for coming. I just want to acknowledge that we're on the lands of the Wurundjeri people from the Kulin Nation. I want to acknowledge their elders, past, present, and emerging. I also would like to welcome all the Indigenous people that are here tonight and everyone else. Thanks for coming, and especially Les. I'm going to introduce Les. Les is a descendant on his father's side from the Gubbi Gubbi Butchulla peoples of the Mary River and Fraser Island region of southeast Queensland, and on his mother's side from the Gamilaroi people of northwest New South Wales. I didn't know that, Les. Very interesting that you're a Queensland supporter. Yeah. Actually watched State Origin with Les in Geneva, and it was very strange watching the State of Origin in the middle of the day. Anyway, getting back to it. Les' working career commenced in 1972 with the Commonwealth Department of Labor and National Services in Brisbane. He was then transferred to Canberra to the newly appointed Department of Aboriginal Affairs after the Whitlam government was elected. In the public service, he quickly advanced to senior positions in the Commonwealth Public Service before joining the Queensland government to become head of Aboriginal and Torres Strait Islander Affairs under the Goss administration in 1990. Les also worked extensively in community control organisations at the local, regional and national and also international levels, and he held important posts in representative bodies of Aboriginal and Torres Strait Islander peoples. He became the chairperson of the Foundation of Aboriginal and Islander Research Action, FARA, what was commonly known, in 1974, and has continued to hold that position on many occasions, and he's currently now holds the chair position. Les was Secretary General of the National Aboriginal Conference, joined the Royal Commission into Aboriginal Deaths in Custody, and was appointed as Executive Assistant to the Chairman of Aboriginal and Torres Strait Islander Commission, formerly known as ATSI. In 2010, he was elected co-chair of the National Congress of Aboriginal First Peoples. He served 2 terms as co-chairperson in this role. Les is highly regarded on his knowledge of Indigenous peoples around the world and relevant human rights standards adopted in the international level. He's also well known internationally for his work on human rights and raising the profile of Indigenous peoples in the United Nations and the Commonwealth heads of government meetings. Les was appointed as a member of the UN Permanent Forum on Indigenous Issues for the term of 2017 to 2019. He has devoted his entire career fighting for rights of Aboriginal and Torres Strait Islander peoples. Les continues to seek change for legal recognition of First People status and rights in Australia. Lastly, and most importantly, I remember when staying with Les in Geneva, whilst doing a fellowship at the UN, Les plays a mean guitar and can sing a song or two. Can we just welcome Les for coming?
Okay, how's the volume? Is it loud enough? Good. Thank you very much, Eddie, for that welcome. And in fact, the words that you used, they were the words I had to cut out of my speech to make it fit in the time frame. So that's good. I get 2 speeches going here. It's been as a formal lecture, it's been a bit of a challenge for me to pick the topic and how to approach what I wanted to deal with. And I picked the title of Breaking Laws and Making Laws from the national to the international, because this wasn't just about Indigenous peoples going out and securing recognition in international law and so on. It was also about trying to emerge from oppression, a lot of it being legislative based, and that being the motive to actually to look for change, because you couldn't live under the sorts of legislation and legal environment that you're in, and you wanted something better. So you first had to break the laws that you were under, and then you had to go and try and make the laws that you want and need. And I'm glad there's question time afterwards, because I'm quite open to answer questions that usually deals with things that I haven't been able to cover. So in 7 days' time, it will be the 16th anniversary of the United Nations Declaration on the Rights of Indigenous Peoples. So I think coincidental that we actually are talking about at this time. 13th of September in 2007 is the date to remember, and always remember. It was the date that international law recognised the identity of the world's Indigenous peoples. The chapter on colonising land, exploiting rich resources and suppressing peoples had finally closed. On that occasion, I had the great honour and privilege to front the General Assembly after the vote on the Declaration was declared, to make a speech on behalf of Indigenous peoples of the world. My 20-minute oration to the General Assembly included the following statements. I would like you to listen to these words, which I have selected out of the speech and are carefully chosen. So it's a few sentences here, about 7, I think. I said the Declaration as a deposition represents a meeting of authorities. It does not represent solely the viewpoint of the United Nations, nor does it represent solely the viewpoint of the Indigenous peoples. It is a declaration which combines our views and interests and which sets the framework for the future. We emphasise once again that the Declaration affirms many rights already contained in the international human rights treaties, but they are rights which have been denied to Indigenous peoples everywhere. Indigenous peoples' right to self-determination is about our right to freely determine our political status and freely pursue our economic, social and cultural development. We realise that a number of states have insisted that the Declaration affirm the territorial integrity of states. But we confirm that territorial integrity, in fact, obligates every state to promote realisation of the principle of equal rights and self-determination of peoples, and to bring a speedy end to colonialism with due regard to the freely expressed will of the peoples concerned. Territorial integrity also requires that a state represent the whole people without distinction and reaffirms that subjection of peoples to alien subjugation, domination and exploitation is contrary to the Charter. Now that the Declaration has been adopted by the General Assembly, Indigenous peoples can reasonably expect that states will, if they do not already have such a relationship, form a collaborative and cooperative relationship with the representatives of the Indigenous peoples to ensure that the rights contained in the Declaration are protected and promoted. So I emphasise things that have been subject of our debates over those years of drafting the Declaration, states' concerns, various things, and so on, and also their insistence on having territorial integrity included in the Declaration, the words, because based upon the 19th century arrangements under territorial integrity, it basically meant the state borders couldn't be interfered with, or so on, and they didn't want Indigenous peoples to have a right of succession on the whole thing. Now, in my youth in the 1970s, I found myself fighting against racist laws of Queensland. We were engaged in supporting the Racial Discrimination Act in 1975, but there was still the need to pursue Commonwealth intervention to address racism. 3 laws were enacted by the Commonwealth addressed towards Queensland. One was the Aboriginal and Torres Strait Islanders Queensland Discriminatory Laws close brackets, Act of 1975, and that was to override specific provisions that were in Queensland laws. Then there was that Aboriginal Councils and Associations Act of 1976. Some of you may recognise that now as the IORC legislation, Indigenous Corporations, but it was actually designed for Queensland because the Queensland government refused to register cooperatives, associations or corporations if they knew that they were Aboriginal ones. And so the Commonwealth created an enabling legislation to allow people to incorporate in spite of the Queensland legislation. And the interesting thing about that legislation at the time, which has disappeared in more modern days, is the word Aboriginal councils. It actually allowed for communities to establish their own system of governance and form governing councils. That's not in the legislation anymore, although I think they put provision in there for people to give themselves a governing function under the Corporations Act, the ORIC. But the point basically there is that people don't want to be corporations. They don't want to be running like boardrooms and businesses and so on. People want to be managing their affairs, and they want to be able to do it in more flexible. And I think that legislation that we're talking about now is better. It's been reformed a number of times, and I'm hoping soon to have discussions with the registrar to see whether it now complies with special measures that we have been campaigning about. And the third one was the Aboriginal and Torres Strait Islanders, bracket, Queensland Reserves Self-Management, close brackets, Act of 1978. And this was over disruption happening in Queensland, Arakoon and Mornington Island, which had been previously managed through the Presbyterian Church or the Methodist Church, then the Uniting Church, were wanting to give self-determination provisions entitled to those communities at Arakoon and Mornington Island, but the Queensland government wouldn't allow it. And so this was legislation to try and override any preventative legislation the Queensland government did. So it just goes to show that growing up in that period, being based in Queensland, that there was a lot on the agenda to be able to be dealing with. I was engaged from the beginning with establishing national representative bodies developed in support of self-determination principles. The first one, of course, was when Whitlam came to power. In Canberra, I worked with people establishing and coordinating the National Aboriginal Consultative Committee, called the NACC, and the employment of liaison officers in the public service to promote the NACC, and also monitoring the progress of the NACC as it met and how they were able to carry out business and so on. In transition from the NACC to the National Aboriginal Conference, it happened in the late 1970s and continued the political development model of the previous organisation, and the leadership in these bodies were becoming more widely recognised and gained traction at the national level. That is, political development was occurring through these processes. The NAC made it clear to government that their agenda already included national land rights and treaty. So we're talking about 30, 40 years ago. In 1984, I actually became the Secretary General of the NAC. The Hawke government came to power in 1983 and was promising national land rights and a treaty. In the NAC, we negotiated new legislation with the Hawke government to protect Aboriginal and Torres Strait Islander cultural heritage. The Aboriginal and Torres Strait Islander Interim Heritage Protection Act was successfully adopted in 1984, following official consent coming from the NAC and an NAC appeal to the opposition through the Shadow Minister to not oppose the passage of the bill. So it was actually lobbied through on both major parties by the NAC at the time. At the time, of course, as you can imagine, there was no heritage protection at all in Australia. The beauty of that interim act is that all you needed to do, if you think something's happening that's damaging sites and so on, is pick up the phone and ring the minister. And the minister could impose an immediate protection based upon a phone call, as distinct from all the hoops you've got to jump through nowadays and generally fail to get protection. Unfortunately, the Hawke government then reneged on the promise to enact national land rights legislation, leading to national protests in Canberra and the subsequent dismissal of the NAC for dissenting against a decision of the government. However, it was too late to stop the agitation for equality and rights. In 1981, the NAC had already successfully hosted in Australia the World Council of Indigenous Peoples Conference, and the NACC, the predecessor, had already attended the first assembly of that conference, which was held in British Columbia in Canada in 1975, and the second assembly was held in Sami Land in September of 1977. So the third assembly of the World Council was held in Canberra and signalled interest that had developed between Australian Aboriginal and Torres Strait Islander people and Indigenous peoples from the various parts of the world. Already the WCIP had shown an interest in obtaining representation at the United Nations and an accreditation to attend UN meetings. The National Indian Brotherhood took out accreditation as a forerunner in order to hand that over to the WCIP. The delegates at WCIP came mainly from the Americas, the Pacific and Scandinavia. The gatherings were significant as Indigenous peoples from around the world came face to face to find that they were having common experiences encountered through colonisation and the brutal doctrines which legitimated genocide of Indigenous peoples and had allowed theft of their lands, territories and resources. In the course of these three meetings, held between 1975 and 1981, Indigenous peoples learned about the various relationships that existed around the world between Indigenous populations of the land and the state. In North America, Scandinavia and Oceania, the Indigenous populations promoted the concept of self-determination and autonomy, where their values and relationships with their territories, lands and resources should continue with minimal external interference. I attended the 1981 Third General Assembly of the WCIP in Canberra. In that assembly, the Third Assembly, the first draft for an international standard on rights of Indigenous peoples was tabled here in Australia. The WCIP had it under consideration also that there be an international convention based upon the right of self-determination and taking into account provisions in the international covenants on civil and political rights and on economic, social and cultural rights. The text was again considered in 1984 at a fourth meeting held in Panama. I also managed to attend that meeting, and has simply become known as the Panama Declaration of Principles, or Panama 1984. But in the meantime, the drafted principles and the ideas for an international standard had already reached the inbox of the newly formed Working Group on Indigenous Peoples or Populations at the UN. The UN was expected to consider protests coming from Indigenous populations as they were compelled to do so in conformity with the UN Charter. But the interest by Indigenous peoples in global affairs was not just a recent meeting at that time. Soon after the League of Nations formed, delegates of Indigenous peoples were making representation to the League of Nations. The first of these was by Deskahe of the Haudenosaunee Confederacy in 1923, significantly 100 years ago from this year, to defend the sovereignty of the Confederacy. They recently held celebration of that in Geneva. Deskahe was the official title for Levi General, an appointed leader under traditional law. His campaign ultimately failed in trying to address the League of Nations, but he gained wide interest and support from the public in Geneva and London. Similarly, other such delegations were being made around this period for Indigenous peoples' identity, traditional rights and autonomy, but directed, as an example, to the Commonwealth, to the King of England, by Indigenous peoples from Australia, New Zealand and the Pacific. Different from the League of Nations, the first worldwide governmental organisation whose principal mission was to maintain world peace, the United Nations was founded upon the principle of equality of individuals and peoples rather than territorial integrity of states. In 1941, representatives of Great Britain, Canada, Australia, New Zealand, South Africa met with exiled governments of Belgium, Czechoslovakia, Greece, Luxembourg, Netherlands, Norway, Poland, Yugoslavia and France and signed the Declaration of St. James Palace, saying that the only true basis of enduring peace is the willing cooperation of free peoples in a world which, relieved of the menace of aggression, all may enjoy economic and social security, and that is their intention to work together and with other free peoples both in war and peace to this end. Even before the war had finished, the Second World War in 1945, the Allies had already established a charter for global peace through willing cooperation of free peoples. So representatives from 50 countries gathered at the UN Conference on International Organization held in San Francisco in California in April to June of 1945. And for the next 2 months, they proceeded to draft and then sign the UN Charter, creating a new international organisation, the UN Charter, United Nations. Poland also soon signed the Charter, and so the UN Charter was established officially with 51 signatures. Article 1 of the Charter sets the purpose of the UN: to prevent threats to international peace, to build respect for self-determination of peoples, solve international problems of an economic, social, cultural or humanitarian character, and promote respect for human rights and freedoms without distinction as to race, sex, language or religion. The preamble to the Charter makes specific reference to peoples, which is a noticeable departure from the source of authority as cited in the Covenant on the League of Nations. Chapter 11 of the Charter has provisions which are also of interest to Indigenous peoples. That chapter deals with the declaration regarding non-self-governing territories. And Articles 73 and 74 under this chapter addresses the interest of peoples where members of the United Nations assume responsibility for territories whose peoples have not yet attained a full measure of self-governance. Now that might sound like that's other places, but again, I have to remind you that Australia was still holding on to Papua New Guinea as a territory and basically had to be enforced after a report was done by the UN or for the UN telling Australia to hand it over. Australia, while at the same time standing up for the principle, was also itself not holding itself to account. As the United Nations became established and grew, a lot of attention was given to international human rights law. And I'm quoting here from the UN pages. The term human rights was mentioned 7 times in the UN's founding charter, making the promotion and protection of human rights a key purpose and guiding principle of the organisation. By 1948, the Universal Declaration of Human Rights laid down the principles that brought human rights into the realm of international law. Since then, the UN has developed protection of human rights through legal instruments and on-the-ground activities. So we know that human rights are universal and inalienable. The principle of universality of human rights is the cornerstone of international human rights law. This principle is repeated many times in international human rights instruments. Many international human rights conventions, declarations and resolutions have been adopted since 1945 to expand the body of international human rights law. This includes the UN Declaration on the Rights of Indigenous Peoples. The Universal Declaration of Human Rights was the first legal document protecting universal human rights. It is generally agreed to be the foundation of international human rights law. Together with the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, these 3 instruments form the so-called International Bill of Human Rights. Delegations of Indigenous peoples have lobbied the United Nations since the World Council of Indigenous Peoples meetings. The goal of the delegates was clear: to ensure that the new global order established under the authority of the UN Charter, including primary role to maintain order through the rights of free peoples, understood and recognised the rights of Indigenous peoples. Building upon a path taken by the Haudenosaunee Confederacy 100 years ago, the United Nations was pressured to hear from the delegates of Indigenous peoples. And the opportunity came when the Subcommission on the Promotion and Protection of Human Rights was authorised to establish a subsidiary body called Working Group on Indigenous Populations. And that was in 1982. The Working Group had the mandate to review developments pertaining to the promotion and protection of human rights and fundamental freedoms of Indigenous peoples, and to give the evolution of international standards, to give attention to the evolution of international standards concerning Indigenous rights. During this period, FERA, my organisation, was also sending communications to the treaty bodies, the human rights treaty bodies, which claimed that Australia, was in breach of its international obligations under respective treaties. The treaty bodies upon which we focused were the Committee on Elimination of Racial Discrimination, which deals with the Convention on the Elimination of All Forms of Racial Discrimination, the Human Rights Committee, which deals with the Covenant on Civil and Political Rights, and the Committee on Economic, Social and Cultural Rights, dealing with the Covenant on Economic, Social and Cultural Rights. It requires some depth of understanding and pragmatic effort to realise how important these treaty bodies are and how impactful their work can be. We know that in 1989, the Aboriginal and Torres Strait Islander Commission, or ATSIC, had been created by legislation tabled by Minister Jerry Hand. ATSIC saw FARA as an effective organisation to advise on policy, laws and political direction. FARA was funded by ATSIC to promote and protect human rights and to provide advice to ATSIC. When the government changed in 1996, just make sure I'm not chopping too big a span here, the Howard government immediately set out to amend the native title legislation, and our organisations around Australia went into a strong lobbying mode to prevent fallout and loss of rights that were protected under common law and recognised in the native title legislation. We could not prevent negative changes made by Parliament, and we could see no resolution to our rights by challenges in Australian courts. So we referred the problem to the Committee on the Elimination of Racial Discrimination, citing breaches of the legislation under Australia's obligations to the Race Discrimination Convention. The committee agreed that the amendments were discriminatory and called upon Australia to appear to the next sitting of the committee. I won't go into further detail other than to say that Australia today is still in the breach of the convention. None of those matters have been fixed up, and there are many recommendations made since that time that Australia has continued to ignore. I believe this is important to be seen as international law in operation. The dilemma being that the Committee on Elimination of Racial Discrimination cannot function as a judicial body, and Australia cannot and will not be compelled to act under international law on human rights. However, in Australia, the public can always hold the governments to account over racial discrimination. Have we seen enough? I now turn attention to the Declaration on the Rights of Indigenous Peoples. The UN Commission for Human Rights created in 1996 a working group to continue the development of the draft declaration. And it involved many meetings over many years, with participation coming equally from states and from Indigenous peoples. As far as we are aware, this was the first, perhaps only, time that the subjects of a human rights standard had been directly engaged in the process of the development of the standard. The working group commenced in 1996, and from that time onwards, I became immersed in these international forums, mostly wearing the FARA cap. I was also engaged in other meetings happening under the Commonwealth Heads of Government, for example, in CHOGM meetings in Edinburgh, Coolum, Malta. Discussions that were going on in the World Intellectual Property Organisation, also the Secretariat of the Convention on Biological Diversity, UNESCO, and the International, I think it's Food and Agricultural Development, and the International Labour Organisation. So you can understand how there was a whole wide range of places of focus talking about Indigenous peoples. The focal point was always the draft declaration, because this was intended to be the platform for the identity and status of Indigenous peoples at the global level. In the drafting stages of the declaration, a constant complaint emerged that self-determination of Indigenous peoples would lead to secession from the state. The short and convenient answer is that there is no right to succession in international law. But more needs to be said on the matter of definitions and their application. And at this stage, I refer back to the speech of the General Assembly that I gave to the Assembly, where I tried to emphasise, now that the Declaration has been adopted by the General Assembly, Indigenous peoples can reasonably expect that states will, if they do not or have not already formed a relationship, form a collaborative and cooperative relationship with the representatives of the Indigenous peoples to ensure that the rights contained in the Declaration are protected and promoted. So I'll just try and get clear on this point. So the idea was this thing about states worrying about succession and Indigenous peoples also being worried about interference in their rights and so on. After the Declaration was adopted, the obvious future arrangement should be where states and Indigenous peoples' leadership at the national level sit together and work together in partnership to work out particular questions. What is the political status of Indigenous peoples is an example. And what sort of remedy should there be for the past inactions or past actions? It might involve genocides, it might involve theft of important lands and resources, etc., etc. These are the things that need to be worked out. We would probably in Australia say, well, that's why Aboriginal people are calling for a treaty. But unfortunately, I don't think anything that I'm saying on this particular point can be reflected in Australia's approach of forming partnership with the leadership. They might say, well, okay, we're going to put in a voice to Parliament, but they're making it quite clear this is an advisory body, we'll make the decisions. Don't get over yourself. So, apart from territorial integrity, the second matter of importance is the importance of territory to peoples and to self-determination. The wording of the UN Charter and the two covenants on the International Bill of Rights make it clear that self-determination is framed around territories, identification of territory, and the identity of the people relies upon the populations associated with those territories. These two elements, self-determination and land rights, were the sticking points in negotiations regarding the draft declaration. It is the reason why the negotiations continued for almost a quarter of a century. And in the final stages, each session of that working group meeting would open with a day for discussion on these 2 points, on land rights, on self-determination, just to try and get closer together between the states and Indigenous peoples. Many of the articles in the Declaration actually provide definition of components of self-determination. For example, autonomy, self-governance, political status, obligations to the constituents and obligations from the constituents of peoples, the recognition of juridical systems, and so on. I often tell people trying to understand self-determination of the Declaration, it's important to read each of the articles to build into their understanding. The details are also important to states to realise that the definition of peoples and the right of self-determination does not similarly confer the right of self-determination upon other groups such as minorities, political dissidents, people of diverse ethnicity within a territory. That was one of the concerns of saying, well, if we do it for Indigenous peoples, all these other groups will come up. And so they have, if you follow any of the workings that's going on in the CBD and WIPO. So who are Indigenous peoples? When the official investigation into the identity of Indigenous peoples, that is officially called the COBO report, was delivered, the result was inconclusive. And I'm quoting here from the UN pages. Indigenous peoples live on all continents, from the Arctic to the Pacific, they actually don't live on Antarctica, via Asia, Africa, and Americas. There is no singularly authoritative definition of Indigenous peoples under international law and policy, and the Indigenous Declaration does not set out any definition. The decision was taken intentionally by the drafters based upon the rationale that the identification of Indigenous people is a right of people themselves, the right to self-identification, and a fundamental element of the right to self-determination. But the description of Indigenous peoples can be attributed to some certain characteristics. For example, Indigenous peoples inhabited their territories long before the arrival of others. They have been subsequently colonised and had their territories overtaken. They remain suppressed by a dominant society and yet still have distinct cultural, political characteristics and maintain strong spiritual connections to the land's territories and resources. Personally, I find that the preambular paragraphs in the Declaration are an important step to understanding the Declaration, self-determination and the identity of Indigenous peoples. And I would like to refer to some particular paragraphs, preambular paragraphs in the Declaration. These are often overlooked. How am I going with time? How many minutes? Sorry? Oh, okay, good. Because I want to read these preambular paragraphs. So preambular paragraph 6 says, concerned that Indigenous peoples have suffered from historic injustices as a result of their colonisation, dispossession of their lands, preventing them from exercising their rights to development. Okay, so there's a good characteristic of description. Preambular paragraph 7 says, recognising the urgent need to respect and promote the inherent rights of Indigenous peoples, which derive from their political, economic and social structures and from their cultures, spiritual traditions, histories and philosophies, especially their rights to their lands, territories and resources. Preambular paragraph 9, welcoming the fact that Indigenous peoples are organising themselves for political, economic, social and cultural enhancement in order to bring about an end to all forms of discrimination and oppression. Preambular paragraph 10, convinced that control by Indigenous peoples over developments affecting them and their lands, territories and resources will enable them to maintain and strengthen their institutions, cultures and traditions and to promote the development in accordance with their aspirations and need. Preambular paragraph 18, convinced that the recognition of the rights of Indigenous peoples in this declaration will enhance harmonious and cooperative relations between the state and Indigenous peoples based on principles of justice, democracy, respect for human rights, non-discrimination and good faith. And the last one, which I like, preambular paragraph 20, emphasising that the United Nations has an important and continuing role to play in promoting and protecting the rights of Indigenous peoples. And I play on that one because as far as I'm concerned, our rights are not going to be protected by the Australian government or the Australian nation, nor by the Constitution of Australia, but by international law and the United Nations. Now, I might be a cynic, but remember I've been in this a long time. I've been on all the ups and downs. So preambular paragraph 20 acknowledges the UN has an important and continuing role to play in promoting and protecting the rights of Indigenous peoples. This is a significant statement regarding UN interests, later emphasised by the UN Secretary General at the time, Kofi Annan, in his address to Indigenous peoples after the declaration had been adopted into international law. He concluded his presentation with the simple words, "Welcome to the UN family." There has been much movement in the UN centred upon creation of bodies, mechanisms and instruments focused upon the rights of Indigenous peoples. I cannot in this presentation give much detail on these, but I'll list some of the bodies and mechanisms. Eddie has already referred to the Permanent Forum on Indigenous Issues based in New York, answering to the Economic and Social Council. In Geneva, there's the expert mechanism on the rights of Indigenous peoples, which answers directly to the Human Rights Commission. There's a special rapporteur on Indigenous peoples and has been there since, I think, the early 90s. There's also an International Day of the World's Indigenous Peoples on the 9th of August of every year. And there is currently now, I think we're in the second year of the International Decade of Indigenous Languages. So these sort of instruments are around. There's a lot more than what I have referred to show that everywhere you go, you can be going, looking at the SDG, the Sustainable Development Goals, and you'll find that Indigenous peoples are making points under that. You can go to the Food and Agriculture Organisation, see them making points under that. You can go to the World Bank and see the Indigenous are making points at that. Not only just making points, but actually being present, being able to talk in these meetings and making progress to recognising that Indigenous peoples have a particular status. And the current goal of Indigenous peoples at the UN is now to achieve observer status at the UN General Assembly and at the UN Human Rights Commission. So I actually was an expert participating in a meeting in November last year in Geneva, to look at how to report back to the Human Rights Commission in October this year on can Indigenous peoples get some form of observer status rather than having to be accredited as non-governmental organisations. They don't accept the non-government tag. They want to be able to involve whenever Indigenous people's issues are being discussed. When the General Assembly adopted the Declaration, I made the decision to work back in Australia. There is a need to get human rights of Indigenous peoples affirmed in Australian law. And the idea is to build a bridge between international law on the rights of Indigenous peoples and the policies and laws in Australia. The National Congress of Australia's First Peoples was created in 2010 as a corporation owned by its Aboriginal and Torres Strait Islander members, not legislated by government, and independent from any control from government. I decided to stand for elections to the co-chair position and was successfully elected and served 2 terms, finishing in 2016. My motivation was to see human rights of Indigenous peoples reflected in Australian law. During my time in Congress, I tried to generate awareness of and support for international progress. The Congress board agreed to adopt the declaration as the Congress standard for human rights and financed a national awareness program for Aboriginal people about the rights of Indigenous peoples. The Labor government agreed to provide further funding to Congress before Labor lost office at the elections, but unfortunately the incoming Abbott government removed that funding from the budget and Congress had to go into voluntary receivership in 2019. The failure of Congress can be put down to government indifference. It's certainly not good faith, taking money out of the budget. And also the failure of the private sector, who the intention was to be able to get funded through the private sector to operate independent of government funding, but not 1 cent was received from private sector. But there's a lot coming from private sector, and whether you say right yes or no. So somewhere I think values are being mixed up in all this. I was appointed to the UN Permanent Forum for a 3-year period. This is a body that meets for 2 weeks each year and reports to the Economic and Social Council. While the time I was on the forum, I was trying to somehow get some reform inside the UN system because the forum itself, the Permanent Forum, was not preparing resolutions for ECOSOC to adopt, and therefore ECOSOC couldn't send on to the General Assembly prepared resolutions or positions. But instead, the Permanent Forum was preoccupied with making deals on delegations to try and get some governments to fund the Indigenous peoples for some project and that sort of thing. Well, I didn't see it as being a marketplace for arrangements between Indigenous peoples and the states. It was a place to make changes at the international level and changes to international law. Through FAIR, I have made a number of submissions to government, the federal government and the state government concerning implementation of the declaration, stronger frameworks for human rights and for treaty. Governments have shown no real commitments to these goals, and I shouldn't use the word no, because some governments have, but at state and territory level. But federal governments have shown no real commitment, and they're no longer representative institutions of Indigenous peoples able to campaign for their own political development and to participate in the life of the state. One of the important elements of self-determination is to have clarity regarding the political status of the Indigenous peoples. The Declaration makes it clear that Indigenous peoples have the right to determine their own political status, to hold and maintain autonomy, as well as to participate in the life of the state if they so choose. In Australia, these questions about status are difficult to approach and to identify. The opportunity to define political goals and take realistic steps towards achieving those goals is not afforded. When national representative structures have been in place, those structures have almost immediately set out what their goals and their aspirations were. But when such bodies are not in place, there is no acknowledgement of nor understanding of the status of the people other than efforts to assimilate into equal citizenship. The agenda is currently defined by government and not by the people themselves. To conclude, I say that leadership is badly needed in Australia from our people from within. For too long, government has, with good intentions or not, assumed responsibility where communities are in need of development. development through self-determination, self-control, and self-motivation. Thank you.
Good evening. For those who don't know me, I'm Matthew Harding. I'm the Dean of the Law School, and I'm going to moderate some Q&A with Les. He's very generously agreed to take questions. Now, we're trialling something a bit different here. There's a QR code up on the slide, and you're invited to post your question just using that code as the way of accessing the platform where the questions are going to be gathered. So let's see how we go. If it doesn't work, I'll just get you to raise your hand. But we've got some. So I might start with this question. In 40 years' time, how do you expect the human rights status of Indigenous people in Australia to have changed? And has the most pivotal moment of such change reached public discourse yet?
Can I get out of that by saying I'll be dead in 40 years' time? But no, in fact, it's a good question. And I don't think there is an answer because there's not really any direction happening. It's we don't really know. Well, we hear treaty, but treaty is still a magic wand that you wave and good things happen. But what are those good things that are needed to happen? And a lot of our people who campaign and say a treaty will fix things up haven't made any effort to address, well, what does it mean about the things that you've got to change? And if you do force people to change, and I was at a meeting that did this with the Brisbane City Council mayor, when they're saying, what are the things, the things should be happening? Well, the demand was for them to change a street sign, change the name of the street. And I'm thinking, gee, I don't get to meet this mayor very often, and if we're just going to ask for to change street names, we're not going to get very far. But I think that regardless of what I think is this sort of treading water position in Australia, the declaration leaves no choice but for there to be a direction. So while there has been, I think, a lot of effort put into the referendum question from both sides and so on, and all people have jumped aboard wearing their hats into the process, there's a lot of energy going into it. I would hope that we will see that sort of activity and interest in actions happening when we get to, in Australia, actually tell people there's a declaration, and we actually get to tell people Australia, has obligations. It's signed these treaties. I think we signed 8 human rights treaties, but has signed these treaties, and as a result of signing those treaties, has accepted an obligation, which is seen in international law as a legal obligation. Unfortunately, there's an inquiry going on in the Parliamentary Joint Committee on Human Rights about strengthening human rights framework, and I'm hoping that'll be one of the things that will come out of that. We'll see a human rights charter, I hope, but the submission I put in was to talk more about the fact that the reports that are coming back from these treaty bodies should be made publicly available. They should be open up to public submission before they're tabled in the Parliament with recommendations from the committee or summaries from the committee and so on, because we don't know anything about it. They come in frequently. Generally, 50% of the recommendations about Aboriginal and Torres Strait people, and if I can be very broad in the generalisation, none of those are ever responded to or dealt with. They just go unwashed. All of Australia's treaty obligations, let's say for the last 30 or 40 years when I've been active and so on, might get to the attention of the Parliament or the Minister if I lobby them, but other than that, the reports go to the Attorney General's Department and they get distributed to the bureaucrats of the different departments, which aren't many, and that's the end of it. Parliament doesn't even see these reports that come in from international. So,
yeah. There's quite a few questions here. So perhaps I'll just pick this one. What do you see as the most important aspect of the UN obligations on Indigenous rights that we need to focus on implementing in Australia right now?
Well, first off, I'd say that I think the UN is doing heaps. So there's no need to send a message to the UN to say you need to do some more specific things. I think it's there. We have people who go to these UN meetings and so on, Aboriginal and Torres Strait Islander people that go and so on, but their focus is not on the declaration, is not upon right of peoples to self-determination, which for me is the only thing to focus on. It has to be particularly in that area. So in terms of the UN has done, I think, as much as you would expect the UN to do. They've sent out delegations. You know, we've had the Special Rapporteur on the Rights of Indigenous Peoples here 3 times. We've had even the, what do you call the Commissioner for Human Rights, the High Commissioner for Human Rights, come to Australia concerned about racism issues here and so on. So we've had lots of people come. I think there was something in the newspaper many months ago about a group going back overseas because they weren't encouraged to look at the administration of justice issues. So they felt, well, we'll come back when you're ready to receive us properly and all that. So one of the things, I think that the Ministers for Foreign Affairs have got a lot of time for Penny Wong, and I think she's someone to work on with all this. I did work very well with Julie Bishop. She went to the World Conference on Indigenous Peoples in 2014 and supported the resolution, which is a very good resolution. I didn't get to bring it up, but maybe I should give that as the answer. There is the World Conference of Indigenous Peoples that was held by the General Assembly where they unanimously passed the resolution, where the paragraphs mostly start with, we commit ourselves to doing this, we commit ourselves to doing that. And one of the first ones that come up, I think is paragraph 8, we commit ourselves to working in conjunction with the national leadership of Indigenous peoples in order to set out a plan of action to implement and recognize rights. It's there, plain language. Australia put their hands up immediately to the wording and to vote for it, and whatever. So I really think the UN has to be better represented in Australia, in the Human Rights Network of Australia, not by them doing anything, but by us chorusing what's coming up in the report. Some places do it. Some people have access to media, good access and ways of getting the media out on the particular issues they're fighting on. But and there is a UN office based in Canberra, which is meant to sort of pass out through Australia and the Pacific media that's coming from out of the UN. But I think we need it. And we used to have a human rights network, we called it, I think, where all the major human rights organisations would meet once a year with the Minister for Foreign Affairs and the Attorney General and talk over what are the problems, what are the issues, but they've disappeared.
Thank you. So there's a question here about working within the UN and its organs itself. The question is, as a change maker, how have you navigated UN institutions with their potential to harm Indigenous people? And I suppose I might add something to that question. If we think about the way in which nation states are asserting themselves more and more at the moment, how is that feeding into those international processes, and how do you navigate that?
Probably a lot of different examples, a lot of different answers, but one of the things is just say, you know, when we were campaigning over the native title changes that were discriminatory, and CERD was really putting a lot of pressure on Australia. I think over 3 years they kept on raising these issues with Australia. Australia wrote a letter to the Secretary General making a complaint about the committee, and that created some sort of diplomatic authority over the operations of the committee and whatever. So the fact that the UN is operated on the basis of states working cooperatively with each other becomes the highest authority. And so if you fall foul of that, then you can get controlled or limited or rejected or whatever. But certainly our organisation and there are people who went over there, we operate a lot, I would have to say by stealth. I mean, we weren't robbing the house, but we would pick up chairs and desks and find a little alcove and sit down and type our speeches and do all that as if we had an office at the UN and whatever. And then also a lot of lobbying. State delegates were always open to being lobbied when they're available on issues because, as happens in domestic parliaments, they rely a lot on the information that they receive. They can't know everything about everything. And so when they get, particularly from civil society, or more importantly, when they get reports, official reports that government have done, used by civil society to point out the things and so on, that is a good way of getting a point across, particularly working with the treaty bodies that I referred to, because they do get flooded with lots of material, lots of paper, and it's one of the ploys, I think, of the government when it does its report, is to actually flood them with irrelevant information and to leave out the important things about their compliance to the treaty and so on. But at the moment, thank goodness, I'm working cooperatively with the government and the departments, where they're keeping me aware of when they're about to put a report into one of the treaty bodies, and they're even consulting me on the draft reports beforehand and so on. So that works, and I've always found foreign affairs to be, I think, the true representation of international order. But if you go to let's say the Aboriginal Affairs area and so on, they're going to give you a more disguised answer about what their position might be on any particular thing. So I've had a lot of trust and faith, a lot of friends in the foreign affairs area, and I think the same should be said of the Attorney General's department, but because Attorney Generals don't have their foot in the international arena, they're not so as open and responsive as foreign affairs.
Yeah, thank you. So here's one that brings us a bit closer to home. So the question goes like this. Laws, including racist laws, are generally written by lawyers. This is a law school. We're not immune from perpetuating these problems. While First Nations students and activist students are very open to both recognising when law is racist and to working against it, it's still a struggle. And we have a number of students here in the room. As a law school, what would you like to see us prioritise in order to help work for a more just future?
Okay, we're looking at it from the law school thing. I first should say, okay, all the racists in the room, put your hands up. Yeah. That's good, see, we're lucky. But no, I was having this conversation deeply with a lawyer yesterday while I was driving down from Brisbane. And it was about the fact that we've been sending Aboriginal people into law schools and through and so on, and we've seen a lot of people coming out wearing the title of being Bachelor of Laws and being more senior positions on institutions and so on. But they seem to have been locked into a mentality of black letter law, of not being prepared, with the speech I gave. It's really looking at the world from the other side, not from the front side that most people see law. And you get different pictures when you challenge things, and it shouldn't be too hard for people to challenge, what is ethically correct or what is consistent with democracy and human rights and so on, because the standards are there now. That's good, and there's a lot of stuff written on it as well. I have to say, probably too much stuff to keep up with it all. But I would say that really in the first 1 or 2 years, it should be embedded into people's minds that the system that you're going to, the legal framework in Australia, is a racist one. Pardon me for saying that, but it is, and that you have to understand why it's in that category. What is wrong with it. And yesterday on the phone, my simple answer was, what does the law say about rights before 1788? And the answer is there was no law in Australia about rights in 1788, before 1788. Well, of course there was law. People's been here for long enough. Not like throw out big numbers, but So the fact that, and I was reading this in a report of the Law Reform Commission when they were looking at the application of customary law and so on, and they were saying there how Aboriginal people tried before courts in the, let's say, early 1800s, the early years and so on, and the fact they had no standing in the courts. And the general understanding was that it's no good trying Aboriginal people in a court because they don't understand the British codes, you know, which is law and ethics and behaviour and whatever. And they don't even come up to the European codes, which are lesser than the British ones, of course, and so on. So, and even now, I think the argument still continues about the problem about the standing of the Aboriginal person in the courts. And the Royal Commission to Aboriginal Deaths in Custody spells this out loudly over and over again every time there's an investigation. You know, well, a policeman shot him, but he walked towards a bullet or something like that. Is usually what the courts accept, you know. And I was talking about my experience on the Royal Commission in Aboriginal Deaths in Custody, where the whole case by the police prosecution was always, this witness is unreliable because I'm getting them to verbally contradict things that they might have put in their statement, you know, because they trick them with the language. You know, are you saying yes, blah, 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 and the person say yes. I said, well, in your statement you said no, gotcha. Like having a referendum. So there's another one.
Well, I'm just looking at the clock, so I think we might have to wind it up. There are quite a lot of questions here, and I'm only sorry we can't sort of deal with all of them. But we've got them on the iPad, so you could read them and talk to the questioners afterwards. Les, thank you very much. That was not only a very wide-ranging and insightful talk, but the question and answer session was just terrific. So thank you so much.
Thank you.
Now, friends, I'm going to invite Eleanor Twomey, who's one of the editors of the Melbourne Journal of International Law, to give the vote of thanks. The journal has joined with the law school in putting on this event, and so, Eleanor, it's over to you to close the proceedings. Thanks very much.
Good evening. My name is Eleanor Twomey. I'm one of 3 editors of the Melbourne Journal of International Law alongside Jonathan Tarr and Jasmine Gann. As many as the questions asked of Les really highlight, I think Les has provided an insightful picture of contemporary challenges in changing laws and doctrines regarding the status of Indigenous peoples in Australia. I believe we've all benefited from Les's discussion of his personal experiences, as well as a mapping of the history and present use of international law, mechanisms and instruments to further the rights of Indigenous peoples, and the pursuit of self-determination. I think pertinent is the point that international obligations are difficult to enforce and to really say, okay, Australia, you need to follow this. But the fact that it certainly forms part of the language and the tools that the public can use to hold the government to account and to fight not only for the voice of Indigenous peoples, but to lead in relevant decision making and have a role in that. The international lens does help us as well to look back at the domestic and sometimes the personal. And I think Les's response to that question in regards to the law school is very pertinent and something we can all think about and sort of imagine how we'll continue to take action on as some of us in the room, members of the institution, academics and students here at the law school. So I'd like to thank Les on behalf of the Melbourne Journal of International Law, Melbourne Law School, and the guests who joined us today for coming down to speak with us. And just to close us off, I'd like to thank MLS, Melbourne Law School, for co-hosting this event, as well as the Indigenous Law and Justice Hub for all their assistance, and Eddie for the introduction. And thank all of our distinguished guests and colleagues for attending tonight. Once again, thank Les, and note that a recording of this lecture, if you want to review anything or share it with friends and family, will be available post-event on the MLS platforms. Thank you.